Hello and welcome to this episode of Law Weekly. I am Shola Shuyeli. One of the big stories of the week is the approval given by President Muhammadu Buhari for the lifting of the suspension on Twitter operations in Nigeria, effective from midnight of the 13th of January. The Chairman Technical Committee, Nigeria Twitter Engagement, and Director General, National Information Technology Development Agency, Kashifu Abdullahi, disclosed in a statement that Twitter agreed to meet all the conditions set by the federal government, and both parties have decided on an execution timeline. The conditions the federal government asked Twitter to fulfill include that Twitter should establish a legal entity in Nigeria during the first quarter of 2022. The legal entity will register with the Corporate Affairs Commission, CAC, and that Twitter has agreed to appoint a designated country representative to interface with Nigerian authorities, that Twitter has agreed to comply with applicable tax obligations on its operations under Nigerian law, and that Twitter has agreed to enroll Nigeria in its partner support and law enforcement portals. The portal provides a direct channel for government officials and Twitter staff to manage prohibited content that violates Twitter community rules, and that Twitter has agreed to act with a respectful acknowledgement of Nigerian laws and the national culture and history on which such legislation has been built, and work with the federal government and the broader industry to develop a code of conduct in line with global best practices applicable in almost all developed countries. Predictably, the announcement generated a lot of reactions, one of which came from a non-governmental organization, the Socioeconomic Rights and Accountability Project, SERAP, which called on the government to compensate those who lost money during the ban. Now, is this a legitimate demand, and do they really have any course of action? I asked the senior advocate of Nigeria, Burkaa, to weigh in on these and other issues. But first, I started by getting his views on how the situation was handled and what lessons all parties can learn from the incident.
Looking at the entire scenario as it has played out, I would say that both parties have actually learned one or two lessons. Now, for me, my concern generally when it comes to issues of this nature is that when government takes steps that has the propensity for affecting any of the provisions of the Constitution, particularly the provisions of the fundamental rights as provided by the Constitution, it becomes a thing of concern to most of us. Whether you like it or not, the ban had a way of affecting some level of our freedom of expression, because Section 39 gives us the right to hold opinion, gives us the right to speak out. It gives us that freedom of speech. Now, when you begin to take steps that has a way of affecting any of this variety of ways in which we can express ourselves, it becomes a problem. But be that as it may, I think that we must understand it from the perspective of the government tried to take a step in protection of what it feels was its own sovereignty, and what it feels was an interference of that by a big tech company like Twitter. And I feel that, for me, the government would have handled it a little bit differently. But what has happened, and we're out of it. But I think that the lessons for both parties would be that for the government, in taking decisions, they must try to take the people into consideration. Now, I know that with the ban, a lot of people who still wanted to use Twitter had to
bypass it
somehow, VPN and all of that.
Yeah.
It is not, you don't, when you put your citizens through those kind of stress, you make them unhappy. And the duty of government is to make people happy. Now, but as I said, both parties have learned. For Twitter, I think they need to understand also that they do not hold the moral compass of the world. I mean, they are a company like any other company. And they should also try to understand they should try to understand the laws and the rules and regulations that's applicable to individual countries. I know of the Twitter community thing of, okay, you have said something, a number of people do not feel good about it, they report that particular statement. And Twitter, without even investigating that complaint to see whether there is some form of mischief within it, will pull
Or
down.
hit down.
Yeah, will pull it down. I think that's not an objective thing to do, because it is possible for a lot of people to just feel that, look, we want this thing down. And I'll give you some very few examples. If somebody like President Trump, or somebody like President Muhammadu Buhari, or somebody like, let's say, the President of South Africa or the President of China says a particular thing, and you feel that you're going to subject him to the same rule that you subject me by saying, oh, because 1,000 people have complained, you pull down his statement. You understand? That's a different personality from me. I mean, he's likely to have more people who would either understand or misunderstand his statements than myself. So sometimes I feel that there should be this balancing act. But be that as it may, I said, well, I just hope that it doesn't happen again. And I feel that both parties, whether it is the federal government or Twitter, must have, within this particular period, come to some form of understanding. I must have learned some lessons.
In all of this, those that are calling for some regulation or a social media law, do you think that there's any justification for it?
It is not possible to have any form of human existence or human activity without some form of regulation. It is not possible, except, of course, we want to delude ourselves, or we want to just create an unrealistic situation of just feeling that everybody will behave well, or everybody will behave with good intention. Now, when people ask for some form of regulation, or they ask for
social media law,
or most of them will be speaking from a position of love for nation and love for actual news and not fake news. So it is not possible not to have that regulation. But you see, the problem that always comes in is when government now steps in to be the one to quickly do that. And people quickly interpret that to mean that, look, there are things you don't want us to say.
Because there's a lot of distrust for government anyway.
That's correct. And that is a problem we have basically in the world today. And it is more in Africa, much more in Nigeria. So government must try to make people have confidence in government. So that when you bring up this issue of some form of regulation, citizens will understand that, look, it is being done for the good of the entire nation. When you see people being edgy over free speech, it is because there was a time worldwide that people could not even say anything. Until this moment, there are countries of the world in which there's nothing you can do. You can mention them. You have them in Asia, you have them in Africa, and people do not want Nigeria to get to that point in which people will be punished for saying things, or people will not be able to say anything at all. Now, when you look at the American democracy and you see the way they operate, whether you like it or not, you love it. You love it in the sense that people are allowed to express themselves. And it is in the form of that expression that government itself learns. So yes, as I said, regulation of some form, particularly regulation of fake news, is key.
Who should drive the process, and how should we go about it?
Ordinarily, it should be the National Assembly. It should be NGOs. It should be civil society. It should be Nigerians who will say, look, you know what? This is, as far as social media is concerned, this is the problem we have. Deal with fake news. And if you're dealing with fake news, Nigerians know very well that you are dealing with a particular thing. I mean, there's no single person today who will tell you that it's about fake news. Not even one. Everybody wants to read information that is correct. Everybody wants the information that will actually be correct. But the process should come from bottom up.
Some people, including this notable NGO, Sarah, have called on the government to compensate those that lost money during the ban on Twitter. Do you think that this is a legitimate demand, and do they have a legal course of action to pursue those claims?
So anybody that has any right or feels he has any right against the government or any group of people is justified to approach the court. Now, some of the things that we thought are not justiciable are becoming justiciable as the day goes by. The world is changing, and we must change the law itself must change. The law itself must move with the times. Before now, we didn't have anything like Twitter. So the question as to whether or not a ban on Twitter will be justiciable is not something you will find in a book that was written 20 years ago, or a book that was written 15 years ago. It's a thing that will have lawyers think outside the box. So if somebody comes to say, you know what, I was on my own, I did nothing, and out of no fault of mine, there was a ban on Twitter, and because of this ban, I suffered A, B, C, D, E, F. It is open to the person to go to court and prove it. A cause of action is something to be determined by a judge, sitting down and looking at your statement of claim. It looks at it and says, okay, fine, you have a cause of action. So for each person who feels that because of this thing, I have suffered this, I have suffered that, the person will have to put that in the statement of claim, and the court of law will determine whether
And articulate their claims
yes,
properly.
then the question will now be, who are you taking to court? Are you taking the federal government or are you taking Twitter?
Who can they have a cause of action against?
So it depends on who you feel has affected or has violated
Federal government,
your rights.
they banned Twitter. But I get your point.
Yeah.
Okay, so away from Twitter and all of those issues, I want to come back to the judiciary.
Right.
I know that later this month, on the 25th of January, the NBA, the NJC, and the Justice Research Institute will be holding a justice summit
Yes.
to tackle issues challenging the judiciary and propose reforms.
Yes.
As a practitioner, senior advocate of Nigeria,
Yes.
what are the major challenges confronting our judiciary in your own view? And when we talk about reforms, what are the things that we need to quickly be looking at addressing that would help the justice system move forward?
No, there's a myriad of issues, but of course you know some of those issues. But when you have such conferences, in order not to turn them into a conference in which everybody come and lament, talk, complain,
because that's all we just seem to be doing. Talk,
yes,
talk.
yes. It's important that we look at those major things that will affect what we do generally. Now we've had the promulgation of the Administration of Criminal Justice Act, which was aimed at fast tracking the justice delivery and criminal justice delivery system. But I think that anybody who has had cause to visit our courts will tell you 100% that our judges are completely overworked and completely stressed. Now, if you go to election petition tribunals and you see judges who sit down there and determine cases, don't forget, while they are sitting down there are cases in their own courts.
Will suffer and
are still waiting for them.
Yes.
In fact, I know of a particular judge who was in an election petition tribunal, and because he did not deliver judgment within 90 days of adoption of final addresses in his regular court, a petition was written to the NJC, and his defense was that, well, I was on national duty, but of course the NJC said you ought to have delivered judgment within 90 days as provided by the Constitution. He was sanctioned. So the point I'm making to you is that anybody who is an observer of our judicial system will tell you that, look, we have judges that are overworked and overstressed. So they do a lot much more
than what we see.
Yeah, than what
physically.
We see in open court.
Yes.
Now, and there's absolutely no reason why we should still be writing, or we should have judges taking down notes in longhand up till this moment in 2022. That is key.
But why has that not worked? Why have we not seemed to be able to solve that particular challenge?
Yeah, I think some courts are trying. I mean, I know a few courts in the Federal High Court who have experienced stenographers. And when you appear in such courts, and you as a legal practitioner get your record of proceedings later, you feel good, because you see the fact that almost everything that ought to be in the record of proceedings will be there. And as simple as that is. Now imagine a judge doing that year in, year out for 10, 20 years. Now, I was talking about election petition matters. By the Constitution, you have a court, the tribunal must deliver judgment within 180 days. That's 6 months. Now, if you have a tribunal that has before it 21, 22, 23, some even have up to 50 petitions, they must determine the whole of those 50 petitions within 180 days. Then it moves to the Court of Appeal. The Court of Appeal has 60 days to determine the appeal with loads and loads of records. Now, when you see justices struggling to ensure that they complete their work within 60 days, you pity them. We must be able to do as simple as appoint more judges. That's realistic. We must be able to also find a way to take care of court recordings. As simple and straightforward as that. Now, I would want to see that addressed. Then another thing which I would want to see really addressed is that the judiciary and the bar must ensure that the law rules. Now, once you have the rule of law, it takes care of a whole lot of things. A situation in which you struggle as a lawyer with your client to get judgment, enforcement becomes a big problem. Or you have institutions that seem to feel that they are above the courts, and even when you have judgments against them, you cannot enforce. It makes a mockery of the entire thing.
Sure.
And that is another thing that is realizable, that is another thing that is achievable, that's another thing that could be dealt with, I mean, quickly. Once the court has spoken, let it be that the court has spoken. The court should not speak, and some other agencies of government or some other powerful individuals
Are trying to interpret
will now come out and say, will now come out and frustrate
that judgment.
Yes, so those are the basic things that I would want to see addressed at this forum. If we start addressing this, there are a whole lot, as I said, but if we start addressing some of these little things, it has an impact. If we address that this year, it means we're not going to be talking about them next year. We'll address other issues and we continue like that. That way, by the time we have 10 years of such seminars and conferences, we would have addressed 10 fundamental issues in the justice delivery system that will assist all of us.